Hey YouTube family and Gen subs, hope you're doing well. I'd like to talk a little bit about my messaging. My messaging is for positive thought, positive facts, positive news. That's what I do, folks. I've been seeing in the comments, some of you don't like positive news during this administration's period, but hey, it's not meant to be hateful. I don't deal with hateful rhetoric. So if you're going to leave a comment, you can disagree with me, but I just want you to be respectful, okay? Be respectful. We can discuss this reasonably and rationally. Hey, what I do is I just bring good news. I bring my good news subscribers information that is positive, and I will continue to do that because that's what they want, that's what they like, and that's what they deserve, to be quite frank. So we got a lot of good news starting this April 2025. I got some updates on the litigation with Venezuela and the Alien Enemies Act. I got an update on the visa bulletin. We got some good movement on employment-based visas. So hey, for those of you who are new to the channel, my name is Humberto R. Gray, attorney at law, and I'm here in sunny Southern California. Have clients all over the country and globally, and I do specialize in entertainment and business. You can go to my website at GrayLaw.com. You can check it out. Just revamped it, got a lot of good stuff there. Alrighty, so we got a lot to get to today, so let's get at it. All right, we got an update from the U.S. Court of Appeals on the Venezuelan Alien Enemies Act of 1798, and it is good news. The Court of Appeal agreed with Judge Boasberg, the district court judge, who ruled that the removal of the Venezuelans is unlawful, at least at this point in the litigation. The U.S. Court of Appeals is very interesting. It's a 3-judge panel. 2 of the judges were appointed by Republican administrations. The other judge was appointed by a Democratic administration. And the ruling was interesting. The ruling stated, quote unquote, that an invasion is a military act, not a migrant act. Remember, they're trying to remove these Venezuelans based on the Enemies Act of 1798. And that law says during time of war or invasion, due process rights are eliminated, and you don't have to have a hearing. You don't have to have attorney representation. You can do whatever you want, and that's what the administration tried to do in this instance. And the Court of Appeals said, no, it's not going to be done. Now, one judge did dissent, and again, I'm just giving factual, fair news. One judge dissented and said basically that the district court may not have had jurisdiction over this matter. That means basically the case that was brought is a habeas corpus case to try to get the Venezuelans out of detention, right? It's called a habeas corpus. Habeas corpus acts have to be brought in the jurisdiction where the aliens are detained. The aliens were detained in Texas. The argument is the case should have been brought in Texas, not in the U.S. district courts. So we'll see what happens. That's going to be an issue for the federal district judge to rule on. And I'm going to keep you updated on this very important case. But at this point, it's great. Due process rights are still alive. Very important for all of us. And we'll continue to keep you updated on this case. All right, let's talk a little bit about the removal, the executive action that's trying to remove the parole programs. So the parole programs that are at issue here are the family reunification program. That's where you have a petition that's pending. You can come here, be paroled into the United States while you're waiting here in the U.S. Uniting for Ukraine because of the war in Ukraine. Ukrainians were paroled into the United States and they're allowed to stay here. And then you have the Venezuelan, Haitian, Cuban, Nicaraguan parolees that are at play here. That case is being litigated as we speak. There's an administrative pause, not a revocation, but an administrative pause on those programs. And it's going to be litigated, folks. We're going to see, they had a date of April 24th, but I think that's going to be pushed for sure. I'll keep you updated on what's happening with the parole program as we move forward. My thought is there's nowhere to go. Haiti is a mess. Venezuela is a mess. These other countries, there's a war. How are you going to send people back to a place where there's war and there's political instability? I think we'll win that case as well. So I put information in the description box below. It is the memo. You can take a read at it, and then I'll keep you updated on what's going on the litigation. Alrighty, so give you an update on the administration's attempt to revoke visas as well as green cards for students who protest. There are two laws that they're trying to invoke. One we talked about is the Alien Enemies Act. The other one is a ground of removability that says if the Secretary of State determines that an individual is involved with speech that is against our foreign policy, that they could just basically remove them, that they can revoke the green card without due process. That's really not going to happen, folks, I got to tell you. So I have an interesting case. I put the case in the description box below, and I'll break it down for you real quickly. It is a Korean permanent resident who's at Columbia, and she was involved in protests. They are trying to revoke her green card. She sued the administration and said, no, that's not going to happen. The ground of removability doesn't apply in this case. And by the way, I am entitled to a hearing for determination on that fact. And so she has sued. We don't have a decision yet on that lawsuit, but I'm going to keep you updated. So individuals are suing the administration as opposed to the American Immigration Lawyers Association and Caresen, etc. Boy, we have a lot of litigation. Currently, there are more than 135 lawsuits that are filed. Lawyers are that line of defense for democracy and for the rule of law. So we'll keep you updated on all these lawsuits. And finally, Visa Bulletin for April of 2025. We got some great movement for the employment-based cases. Check out the Visa Bulletin here. I put a link in the description box below. And so for this month, April, for family cases, you can use the filing charts to file your adjustments. For employment-based cases, you have to use the final action date to file your adjustments. All right, YouTube family and GN subs, thanks so much for watching GrayLaw TV. Click below, like, and subscribe. Go to my content. I have lots of good content. Again, check out my website at GrayLaw.com. I just revamped it. It's all brand new. Great photos of my staff, etc. And hey, thanks again for watching, and we'll see you next week.